Hello, everyone. It's our pleasure to be presenting the Data for Policy 2021 conference. And my name is Stergios Aidinlis. And with me together, I have my colleague Hannah Smith. We are both researchers at the University of Oxford. We are presenting today submission number 47, entitled Providing Access to Justice Data for Legal Tech Innovation in the United Kingdom. And we have been working on this project as part of the AI for UK Law project at the University of Oxford, alongside Professors John Armour and Jeremias Adams-Prassl. So today we will be presenting our submission about the governance of access to justice data for commercial legal tech entities in the UK. And we will be starting with some, let's say, caveats and clarifications about the background and the scope of our inquiry, before going to the core of our arguments about the lawfulness and the lawful grounds for processing for justice data by commercial entities. Now, first of all, why is this a very important and topical question? And we start by giving some background about this question. So in the United Kingdom recently, this big digitalization reform has been initiated by Her Majesty's courts and tribunals, where many many processes of the judicial system will be moved on the online realm, and substantial amounts of justice-related data sets will be collected or updated in the way they are collected currently. All this will be available in a digital, let's say, format, and this sparks huge commercial interest in getting access to this type of data in the interest of producing cutting-edge legal analytics. Now, this kind of legal analytics will be, let's say, machine learning and other predictive technologies that will be using previous justice data sets to be able to make assessments about the likely outcome of judicial cases and other processes. It is believed, and there's a great policy interest in this activity, that there is a great potential to enhance access to justice. This is because currently specialized legal advice is a very expensive service, and the type of legal analytics we are talking about can provide insightful and evidence-based legal advice at the fraction of the normal cost of that service. Our research question in this inquiry is whether it is lawful for the Ministry of Justice to allow commercial entities access to data sets belonging to the Ministry of Justice and held by the Ministry of Justice for the purpose of producing legal analytics of this kind. If this is lawful, which is the appropriate lawful basis in data protection law that should be invoked in order to allow this type of access to happen? Now, a few clarifications about the scope of our project. We are talking about justice data, but there are certainly many different types of justice data. There are the actual textual data that are judgments and other types of data like witness statements, testimonies. There are also metadata about justice data. So like the elements of how long does a trial last, how many people were involved in a trial, how many litigants, how many lawyers represented the litigants. These are data about the data that are the judgments. In our case, we have confined our inquiry to textual data. We're mostly thinking here of judgments because this type of data bears the greatest potential to enhance the access to justice policy interests that lie here beyond, let's say, behind our inquiry. It's important to also mention that there are some really important policy developments in the United Kingdom recently in the interest of making access to judgments easier, and the Ministry of Justice have agreed recently to facilitate a more systematic collection and publication of judgments by the National Archives, as opposed to the current state of play where not all judgments are available, and most judgments that are available are held by Bailey, a charitable trust. Beyond this clarification about justice data, we also have to draw this caveat about the type of data in the legal sense under data protection law. So it's far from self-evident that data protection legislation will always apply when it comes to using justice system data for the purpose of producing legal analytics. So the question of identifiability, in other words, the property, let's say, of some data as being potentially relating to an individual and being able to be used to identify an individual, is not always present when it comes to data sets in the justice system. That means that data protection laws will not always apply, and it might be the case that the public authorities and the commercial entities will not need to demonstrate conformity with these laws. That being said, some consideration of the matter, some careful consideration of the matter demonstrates that some information, mostly referring here to the names of the judges and the names of the lawyers that represent the parties, will be very likely needed by commercial entities if they are to produce robust and evidence-based assessments of how likely particular claims are to succeed or not. With that in mind, we think this inquiry has a very much important role to play in figuring out how this type of innovation is governed in the public sector. Now, we have talked about the application of data protection laws. There are certain different sources of law. It's not only data protection that applies, but in terms of data protection, we refer to the Data Protection Act 2018 in the UK, which transposes the European Union GDPR in the UK legal order. We should also mention that because of the recent adequacy decision by the EU Commission, the United Kingdom is quite likely to conform to EU-level safeguards in data protection if it is to retain the free flow of data between the continent and the country. And with that in mind, we're not very likely to see huge deviations in terms of the legislation with regard to the GDPR. Beyond that, there is also the Digital Economy Act, which is, let's say, a part of regulating the powers of public bodies to share data for different functions, including research activities. And there is also human rights law. That means the Human Rights Act 1998, transposing the convention that regulates, actually transposes the human rights like privacy and data protection that are applicable in this context. Now, coming to the actual core of the question, can the Ministry of Justice share those data lawfully? Which are the grounds that the Ministry of Justice should rely upon under data protection law? We are coming to the heart of the question, and considering that consent is very difficult to apply when we have huge data sets like the ones in our case, there are two main candidates here at play. The public interest under Article 6.1e GDPR and legitimate interests under Article 6.1f GDPR. So the public interest is the legal basis that is invoked when some kind of processing is necessary for the performance of tasks in the public interest or in the exercise of official authority vested in the controller. Legitimate interests, on the other hand, are invoked when processing is necessary to pursue the legitimate interests pursued by the controller or by a third party, as long as the caveat that is mentioned in the article is satisfied. And we'll come back to that about the balancing with fundamental rights in a moment. Now, in our case, we want to present three potential constellations that we have come up with in reasoning and interrogating, let's say here, the lawfulness of providing access to justice data for commercial entities. We should mention from the outset that these are not necessarily, let's say, mutually exclusive alternatives, that everyone has to only decide that one of them is applicable. Data sharing collaborators might have more than one options, but then we'll need to decide what fits better the interests that they have and the safeguards that they have to apply to protect the fundamental rights of data subjects. So the first type, the first constellation that we envisage here is what we call public interest processing. And in this case, the Ministry of Justice or the HMCTS or the judiciary remain the data controllers with the commercial entity only playing the role of the data processor. In that sense, we see a very clear correlation with the public good, but that means the commercial entity will not be able to repurpose the data or to change later what it will do with the means of processing. They have to stay within the pre-agreed confines in terms of what happens with the justice data. That type of, let's say, collaboration, this first constellation has this advantage of having the clearest connection with the public interest. The second type, which we call hybrid processing, involves the commercial entity in a potentially more, let's say, advanced role as also a data controller. In that case, there can be a combination between the public interest and legitimate interests, which we claim are not necessarily zero-sum as terms between them. And the important thing in this constellation is for all the entities in this collaboration to demonstrate the proportionate relationship between the public interest and legitimate commercial interests. So potentially, and as long as a tangible contribution is being made to the public good, commercial entities might be able to repurpose the data to pursue their own interests to the extent that the proportionality assessment allows this. Finally, the third constellation we present here is what we call legitimate interests processing. And in that case, the MOJ and HMCTS and judiciary will not invoke the public interest at all. They will rely on the legitimate interests of the third party in order to disclose the data to allow the commercial interests of the legal tech entity to be pursued. We feel that while this is not excluded by the law, it certainly lacks this connection with the public interest that is really important in this area to enhance access to justice. Now, as a result, to summarize the three constellations, we feel that in principle, the public interest can be invoked, as we mentioned, by commercial entities. And of course, we need to be very careful because regulatory guidance has been cautious about allowing private companies invoking the public interest. Some clear-cut cases like water companies serving public utility through providing water to communities have been acknowledged, but apart from that, it's important not to have public interest washing by commercial entities claiming to be serving the public interest only as an excuse to pursue purely, or let's say, hugely biased in terms of the balance commercial interests and purposes. That brings us to the final part of our presentation, the second part of the presentation, which is about the boundaries when it comes to invoking legitimate interests. And with that opportunity, I will be giving the floor to my colleague, Hannah.
Thanks, Stergios. So yes, the rest of this presentation takes a closer look at the potential application of the legitimate interest ground to render this data processing lawful. The focus arises from the potential difficulties with relying on the public interest ground, as mentioned by Stergios. Now, this is not completely impossible. Before COVID, as Stergios mentioned, already we had identified certain commercial entities, such as utility firms, that may rely on this ground to process data. During COVID, we also saw commercial entities involved in the contact tracing apps that became so ubiquitous. And public health was mentioned specifically in the GDPR and the prevention of epidemics as a ground in the public interest. What they do demonstrate is the high bar that commercial and private entities must cross for them to demonstrate that they have this public interest ground, that their activities almost need to be indispensable. And currently, we're not convinced that we can make the argument in this context at this very moment. And therefore, we propose the ground of legitimate interests may be a route for demonstrating the potential lawfulness of this use of data. And to do that, we draw upon the ICO's legitimate interest assessment and existing case law. we use these materials to emphasize the potential continued applicability of existing principles as a means of facilitating appropriate uses of data, and their ongoing utility in guiding novel data processing activities and new partnerships that may be fostered in this area. We see this as a real strength of the law and regulation in this area, providing that delicate balance of flexibility and certainty. So the ICO's legitimate interest assessment has 3 stages that we shall look at in turn for data processing, that it needs to demonstrate all 3 of these stages for the processing to be lawful. So we will look at, in turn, the purpose, the necessity, and the balancing. So first, we need to determine if we have a legitimate interest in this context. And regulators such as the ICO have acknowledged that this is a broad term. Next slide, please. So whilst it precludes unethical and unlawful uses of data, it may encompass trivial, controversial, or commercial interests in light of the balancing test that takes place at the end. And the Article 29 Working Party highlighted that the notion of an interest was broader than a purpose in terms of a specific aim or outcome. So whilst there was a need for some clarity to the legitimate interest, this clarity was looked at in the terms of benefits. And therefore, one would have to be able to articulate a benefit to a third party that must be real and connected to the activities of an entity. But nevertheless, this notion of benefit encompasses benefits accruing to the processors, controllers, third parties, data subjects, and the wider public. And we believe that the data processing we are looking at could fulfill that definition of the legitimate interest by references to the benefits that it could bring to a range of actors impacted by this use of data, which not only includes the Ministry of Justice and the legal startups, but also the broader public in terms of facilitating access to justice, reducing barriers to access to justice, and also facilitating innovation and economic growth in a fast-growing area. Next, we need to determine the necessity of the processing, which the ICO has acknowledged as a bar lower than essential, but requires the processing to be proportionate and adequately targeted. Now, a definitive answer cannot be given because this will be a fact-driven assessment. So it must be done on a case-by-case basis, but reference should also be made to some of the principles in Article 5 of the GDPR, such as data minimization, when we're thinking about what would be necessary in a certain context. Finally, we need to consider whether others' rights and interests are nevertheless sufficient to override the identified legitimate interest. This is why the use of controversial or trivial legitimate interests may be more difficult, because they may be more prone to being overridden in light of others' interests in this area. Nevertheless, a negative impact on individuals does not automatically exclude a reliance on a legitimate interest. As a balancing test, it relies on the severity of the impact and whether this is warranted in light of what is being pursued by the data processor or data controller. Now, in applying this stage, we need to consider 3 things. The first is the nature of the data. The more sensitive the data is, the more it pertains to vulnerable populations, the more likely it is to override the legitimate interests. But as Stergios has already mentioned, in terms of the data of interest here, it need not be necessarily that very sensitive data that we might automatically think of when we think of justice data. The use of metadata and the use of characteristics of actors beyond the claimants or applicants or defendants are of significant interest to legal startups and may not be as sensitive and therefore may not be overridden, may not override the legitimate interest. So there is potential for the legitimate interest to nevertheless override. Secondly, we need to consider the reasonable expectations of data subjects. Now, it may be difficult to speak of specific and concrete expectations in this context, because many may not be aware of how data may be reused and repurposed in this context. But it isn't beyond the realms of possibility to believe that people reasonably expect public entities and private entities to work together to ensure the effective and efficient use of resources in a way that benefits broader society, either through reducing barriers to access to justice, providing insights as to the workings of the justice system, or through, again, facilitating economic growth and innovation. And we may also see these expectations being shaped by shifts in our understanding of what is being done with data in terms of open justice as a movement and in terms of the increased publication of judgments. Finally, we consider the impacts and safeguards on individuals when considering whether their interests override. Here, the impacts on individuals appears to be very minimal. No physical harm, no financial loss, no economic or social disadvantages are reasonably likely to arise as a result of the insights generated. Furthermore, safeguards such as data minimization and transparency could be applied to this context to help protect individuals' interests. And therefore, we feel that there are instances of this use of data that can demonstrate a legitimate interest ground that is not overridden by others' interests in this area, and therefore is a lawful ground for processing. Now, our final slide, I just wanted to outline the case law in this area that emphasizes what is required in this context, and that is a context-specific evaluation of the specific circumstances of what is being done here, and that there is a need to respect individuals' interests, but on the other hand, there is a limit as to the clarity you can provide in advance. And in one of the most random pop culture references ever before the court, as noted by Advocate General Bobeck, it is an accommodating legal category where the application of necessity shall not turn to the realization of a legitimate interest into a Kafkaesque treasure hunt. And there is a later reference to Fort Boyard. So in summary, we believe that there will be examples of this use of data that will be able to demonstrate a legitimate interest, and therefore will be able to demonstrate the lawfulness of this processing ground. But we will continue further work in this area to provide further clarification and guidance and an understanding of the constellation. Thank you for listening.